Welcome back. This is attorney Nicholas Hicks, and this is New York Child Support Part 4. And this is our final installment in the child support section of videos. And again, there's so many parts to most areas of law. This is not intended to cover every possible scenario. I could make 50 videos in an attempt to try to cover every possible scenario, but I wanted to give you an overview of child support so that you sort of have an understanding of how it can work in New York State. And our discussions involve New York State law only. It is not intended to give legal advice, but it's for informational purposes only. You should consult a New York attorney to see how the law applies to your particular circumstances. So, if you'll recall, the last time we left off, we were talking about the consequences, the possible consequences for failure to pay child support. And by the way, if you're coming in later on in this series, I would strongly suggest that go back to part 1 and sort of follow the videos from 1 through 4, because they're meant to sort of latch on to each other, and you really want to get a complete understanding of the subject. So go back if you haven't watched the other 3 segments. Now, I want to pick up today with what terminates the child support obligation. And you will recall that parents generally are chargeable with the support of children less than age 21. So that in most circumstances in New York State, the child support obligation terminates upon the 21st birthday of that child. Now, there are circumstances where that may not apply, and let's talk about what some of those circumstances are. For example, if the parents have an express agreement with each other that child support will continue past the age of 21, then the support obligation will be beyond age 21. The typical circumstances where, for example, a child is in college and the child has reached the age of 21 but has not yet completed his or her education, which and nowadays is very typical because of the expenses involving college education. Sometimes courses can't be picked up in time because the class size has reached its maximum, and a whole host of reasons. And so for whatever reason the child has not completed his or her education, support might continue until age 23 or 24 or 25. I've seen all kinds of numbers. But again, it has to be an express agreement between the parties. So again, mom, for example, can't tell dad, no, you've got to pay me support beyond 21 because, you know, John hasn't finished college yet. Can't force the other parent to do that unless there's an express agreement to do so. Without that express agreement, the obligation terminates at age 21. Now, another circumstance that will cause or can cause the termination of a child support obligation is the emancipation of a child. I've had cases where the parent will come to me and say, look, my child is 18 years old or 17 years old or 19 years old, and against my wishes, they've moved out, they're not following any of my rules, they're paying rent, they're working, they don't want to obey my rules. I don't want to continue to have to pay them support. What can I do about that? And in some of those circumstances, we've petitioned the court. The court has conducted some kind of hearing or inquiry, and if we can establish that the child is self-supporting, has left the household, perhaps against the parents' wishes, does not want to obey the parents' rules, the court can find that that's an emancipated child and terminate the support obligation. Or other circumstances, the child may have gotten married and is living in their own residence with their spouse. That can cause the court to determine that a child's emancipated and that the support obligation therefore should be terminated. Of course, the death of a child will terminate the support obligation. So these are some of the situations that terminate the child support obligation. Now, of course, in this world, things don't always work perfectly. So I've had circumstances where a client was paying support through the child support collection unit, and the money was being taken directly out of their paycheck, or they were sending payments in, and the child turned 21, and the support was still being taken out. It may be the case that you may have to go back to court to get an order to stop the support collection agency or the unit from taking monies out. So sometimes you have to be very vigilant about that. Sometimes magic doesn't happen on the child's 21st birthday. You may have to take action to ensure that you're not paying child support beyond the child's 21st birthday. So you have to keep an eye on that, because sometimes the support collection unit is not keeping an eye on it and is simply just pulling money out. So you have to be vigilant about that. Now, another instance where, and it's rare, but it does happen, where support termination can occur, is where, for example, an older child refuses to see or visit or spend time with the non-custodial parent. There are cases in law that says that in extreme circumstances, let's say a child is 18 years old and there's still 2 or 3 years left of the support obligation, and the child doesn't want to be bothered with the parent who's paying child support, and the parent is attempting to they want to spend time with the child. The child doesn't want to be bothered, and this is going on for an extended period of time. That parent can make an application to the court seeking termination of the support obligation based on that older child's refusal to see or otherwise have any kind of relationship with that parent. Now, again, it has to be an older child. It has to be a child for which parents can't control. I mean, you can take an 8-year-old, obviously physically put them in a car, take them to dad's house, go in the house, see dad. I mean, even if the child doesn't want to, but an older child, you really don't have the ability to physically make that child go anywhere or do anything. And so in that instance, there has been situations where a court has said, then since you don't want to have a relationship with your parent, we're going to relieve that parent of the obligation of having to support you. So that has happened. Now, I do want to tell you about sort of what would appear to be an odd situation, and there are many of those situations. But we talked quite a bit about the non-residential parent paying support to a residential parent. However, there have been circumstances where the residential parent has had to pay child support to the non-residential parent. And you might ask, well, how could that possibly be? Why would I have to pay child support to the parent where the child doesn't live on a regular basis? And often what the circumstances are is that, first, there is a pretty big disparity of income. That is, that the residential parent makes quite a bit more money than the non-residential parent. Or maybe the non-residential parent isn't working at all, or is on some kind of disability, or makes a very small amount of income. The logic is, well, when the child goes to spend time with the non-residential parent, there needs to be an apartment or place for the child to go to. There has to be lights and gas, and there has to be food in the refrigerator. And so there have been situations where a court has said, you, the residential parent, although the child lives with you, and although there is a presumption that you support your child because the child lives with you, you must still pay some amount of support to the non-residential parent in order to ensure that the needs of that child is met when they're spending time with the non-residential parent. So that does occur. So again, I hope that you've enjoyed this series. I hope that it's been helpful to you. Stay tuned, because we have so much more to talk about with respect to a number of legal topics. Again, I'm attorney Nicholas Hicks. Thank you for joining me. Take care.